Thank you, Mr. Speaker. I'm pleased to rise in the House to speak on Bill C-59, an act respecting national security matters. This is a very large bill that seeks to make some major changes to our national security. It affects Bill C-51 that was brought in by the previous government, our government. It replaces the Security Intelligence Review Committee and the Commissioner of the Communications Security Establishment with a new National Security and Intelligence Review Agency. It creates the position of Intelligence Commissioner to provide day-to-day oversight of the national security activities. It limits the Canadian Security Intelligence Service's ability to reduce terrorist threats. It limits the ability of the government departments to share data among themselves to protect national security. It removes the offense of advocating and promoting terrorist offenses in general, and it raises the threshold for obtaining a terrorism peace bond and reconnaissance with conditions. Obviously, Mr. Speaker, there is a lot in this bill, and will not have time to speak on all of it. So I will focus on a few key areas that I have concerns with. As most of you will know, extremist travelers are those who have left Canada or other countries to join terrorist groups abroad. As ISIS continues to lose ground in Syria and Iraq, supporters of this militant group and other terrorist organizations have returned to their home countries, Canada included, with almost 60 of them now returned. According to a recent report that was released in October from the Sofan Center, a US-based nonprofit organization, 33 countries have reported arrivals of at least 5,600 extremist travelers. 5,600 of them now returning home. The report states that those returns represent, quote, a huge challenge for security and law enforcement entities, unquote. Now is not the time to relax the laws that protect our national security. Canadians are at risk. Canada is not immune to the threats of terrorism. We have seen an attack on Parliament Hill, the terrorist attack that killed Warrant Officer Patrick Vincent, and the recent attack of a police officer and members of the public in the city of Edmonton, just next to my riding. We need strong legislation in place to protect our national security and our citizens. This is why our Conservative government introduced Bill C-51, which has been used to disrupt terrorist activities nearly 24 times that we know of. This includes when law enforcement and intelligence officers intervened last year to stop an ISIS supporter, Aaron Driver, who had planned to commit a terror attack in Canada. These attacks and attempted attacks demonstrate that Canada needs strong security and intelligence legislation that enables public safety agencies to do their job. Prior to our previous Conservative government's Bill C-51, CSIS mandate prevented it from engaging in any disruptive activities. They could not approach the parents of a radicalized youth and encourage them to dissuade their child from traveling to a war zone or conducting attacks here in Canada. After Bill C-51, CSIS was able to engage in threat disruption. Warrants were not required for activities that were not contrary to Canadian law, such as approaching the parents of a radicalized youth. This was very reasonable, in my opinion. But now, Bill C-59 will limit CSIS threat disruption activities to very specific actions. Mr. Speaker, they will require a warrant for simple and necessary activities such as impersonating a local citizen to give a suspect the wrong directions in order to disrupt a threat. This bill unnecessarily limits and restricts the ability of CSIS to disrupt threats to national security. Bill C-59 also makes it more difficult to obtain a peace bond for terrorism cases. Mr. Speaker, we should be going forward. We should be strengthening the laws in Canada not reducing them in the favor of terrorism. Under Bill C-51, a peace bond can be issued if there are reasonable grounds to fear that a person may commit a terrorism offense, and a peace bond is likely to prevent terrorism activities. And that is the same as a peace bond under the Criminal Code of Canada, which I have applied for a number of occasions over the years as a police officer. When I know someone may pose a threat to an individual, has indicated that she or he may pose a threat to an individual, I have gone to a judge and had a peace warrant issued to protect that person and protect the possible victim. Bill C-59 increases the threshold from is likely to is necessary to prevent a terrorist activity. God, if we have evidence out there, Mr. Speaker, that someone is planning and we can't act on good, sound information, it's going to be a sad day for this country. This means that the amount of evidence that would go into proving that the peace bond is necessary is nearly the same as the evidence you would need to lay a criminal charge. So if you look at those set of circumstances, why would you go in for the peace bond? You might as well do the criminal charge. It's a little late. The point of peace bonds is that there is not enough evidence to arrest and charge that suspect, but there are reasonable grounds to believe they are involved in terrorist activities. That's reasonable, Mr. Speaker. It's reasonable under the Criminal Code to believe that if somebody threatened to kill a person numerous times, that maybe there should be a peace bond issued for that person to stay away from the possible victim. If the government raises the threshold to obtain a peace bond, people who are at risk to national security will slip through the cracks. And we now have 60 of them in this country. How are our police forces supposed to keep us safe, Mr. Speaker, if they cannot request special safety conditions be put on someone likely to engage in an attack? I also find this bill problematic in addressing the issue of advocating and recruiting for terrorist groups. General and broad threats against Canada or all infidels is not a crime under the Criminal Code. Hate speech and threats need to be directed at an identifiable group. Bill C-51's definition of advocating or promoting terrorism enables law officers to promote more effectively pursue those disrupting radicalized propaganda and advocating violence, and it should. However, the bill before us today deletes this offense. Without the ability to target the advocacy and or promotion of terrorism, law enforcement will be handicapped from effectively addressing the various ways that individuals are radicalized. This includes removing terrorist propaganda from the internet. Another concern change is in Part 8 of the bill, which amends the Youth Criminal Justice Act. If we afford more protection to young offenders guilty of terrorism offenses, youth will become a target for radical recruiters. Instead of cracking down on radicalization, the Liberals are actually creating loopholes that those who seek to radicalize youth can exploit. One last problematic area I want to highlight is Part 5 of the bill. This section amends the Security of Canada Information Sharing Act that was established by Bill C-51. The changes made by today's bill make it more difficult for government departments to share information with each other. As a former police officer, I know how necessary it is able to share intelligence when conducting a very large scope investigation. It can make or break a case. And I can tell you that we have problems when it is easier for our own agencies to share information internationally than with each other. While our Five Allies are all taking measures to strengthen national security, this legislation removes the ability of our intelligence services to reduce terrorist threats. In the last year, horrendous attacks in the United States, Europe, and our own country, Mr. Speaker, have shown that no country is immune from the risks associated with terrorism and radicalization. The Anti-Terrorism Act brought forward by our previous government struck a careful balance between protecting the civil liberties of Canadians while adequately providing law enforcement with the necessary tools to keep Canadians safe. It is the responsibility of the government to ensure all of Canada's security and intelligence services have the tools they need to do their job. My time? Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Renfrew, Nipissing, Pembroke.
Thank you, Mr. Speaker. Now, we have, on the one hand, a group of individuals in our special operations forces who are facing, if they've been injured by one of these terrorists, a significant drop in remuneration if they don't fully recuperate within 6 months. Now we have a number of individuals coming who are so now euphemistically called foreign terrorist travelers, which the government minimizes to about 60, when we know just last year there are at least 180, and then that's discounting the mass migration of people across our borders without the full vetting that needed to be done. So my honourable colleague was a former police officer, as he referred to. I'm wondering if he could quantify the costs of keeping surveillance on one individual and how having to do so on 180 minimum, maybe 1,800, would compare to the money that they're taking away from the soldiers whom the people they're mollycoddling into Canada were fighting against and bombing.
The Honourable Member for Yellowhead.
I'd like to thank the Honourable Member for that question. Wow, 180 people. The cost will be astronomical to this government to look after that many. The money that we're looking at to protect our soldiers that return from injuries and stuff would just be a small portion of what it would cost for this government to keep track of 60, 100, 180 people. We need to keep track of them. They are now mentally prepared as terrorists, and they're coming back into this country, and you think that they can switch that off like that? It's impossible. They are going to react, and they are going to follow through in what they have been trained at in the last 3 or 4 years, depending on how many years they've been over fighting in ISIS. It's no different than taking a police officer who worked undercover with a motorcycle gang. He can't just switch back. It takes a deprogramming. It takes sometimes 2 to 3 years. This is exactly what we need to be concerned with, the safety of Canadians.
Questions and comments? Questions and commentaires? Questions and comments? The Honourable Member, l'Honorable Député de Drummond.
Merci, Monsieur le Président. Et je sais que mon collègue et moi ne sommes pas d'accord sur le projet de loi C-59, sur l'essence même du projet de loi, sur C-51, ce projet de loi-là visait à corriger C-51. Et comme mon collègue le sait, j'ai voté contre C-51. Mais une fois que ça c'est dit, est-ce que mon collègue n'est pas d'accord avec moi que ça sent l'improvisation du côté des libéraux? Apporter un projet de loi comme ça, malgré que ça fait 2 ans qu'ils travaillent là-dessus, mais il apporte un projet de loi et tout de suite, on se rend compte que ce projet de loi-là a plein de failles. Il faut l'envoyer au comité au plus vite parce qu'on ne peut même pas débattre en deuxième lecture de ce projet de loi-là. Alors, est-ce que mon collègue n'est pas d'accord avec moi que ça sent l'improvisation de la part des libéraux, encore une fois, et que s'ils ne sont pas prêts, là, à déposer C-59, si le projet de loi n'est pas prêt, mais qu'ils retirent le projet de loi, puis qu'ils travaillent avec l'opposition pour une fois, puis qu'on arrive à une solution qui va être beaucoup plus équilibrée puis mieux préparée.
The Honourable Member for Yellowhead.
I'd like to thank my honourable friend for that question, Mr. Speaker, and he is absolutely correct. This Bill C-59 is full of flaws, and as the Liberals stated earlier today in one of their statements, that it was a election promise that they made, and I don't think there's any room or any place in Canada's security to be worrying about an election promise versus the security of Canadians. And I believe that this should have gone back for a lot more debate, and this bill should never have been presented in the format it is. It's wrong in many cases, and it is hurting a very good bill, Bill C-51, which may have possibly have some flaws, but not very many, and things can be reviewed and corrected.